right now.
Rosalind, you're a little bit in and out.
I am?
A little bit. Does anyone
Is
else
that
hear me?
better?
It's me.
Yeah.
Okay, I'll try and speak a little bit louder and in the microphone better. Okay, so today is August 11th, and it is helpful if people who are not speaking or not board members keep themselves on mute until we request anyone else to speak, because otherwise we can't get through this. Today is August 11th, 2020, and we are holding a virtual continuation of a previous hearing regarding 156 Bass Road in Nahant. We are the Nahant Zoning Board of Appeals. And typically, we introduce ourselves, we go over the reading of the advertisement. On this occasion, we are not going to do that because we've already read it in this hearing. We're going to commence our hearing on 156 Bass Point Road at this time. And as you may already know, that we are holding this hearing pursuant to Governor Baker's March 12, 2020 order suspending certain provisions of the open meeting law, General Law 30A, 18, and the Governor's March 15, 2020 order imposing strict limitations on the number of people that may gather in one place. This meeting of the Town of Nahant Zoning Board of Appeals will be conducted via Zoom technology, and specific information about that is posted on the Nahant website. So we shall commence. Our first order of business today is the continuation of the hearing regarding 156 Bass Point Road. And at that last hearing, Mr. Glenn Kennedy of Remade LLC had presented some plans and some documents, and the board had suggested that he revise those plans. And he did so, and he submitted the revised plans to us. And I want to make sure everybody had a chance to look at them. Have all the members seen them?
I did not receive them.
Okay. They were sent to you by Tim Campo in the building department. I'll send you a copy right now, Peter.
Okay.
Okay.
Yep. I can look at.
Yes, I'm sure you can.
Yeah, the attachment was corrupted on that when she sent it to me. I should have probably done it at that point.
That's okay. Which email do you want me to send it to? I'm going to forward it from my
Capital One, because that's yeah, that's the one I can look at it.
Okay, can you just give it to me verbally because I'm on my home computer?
Yep, Peter.Barba, B-A-R-B-A, at CapitalOne.com.
Peter.Barba, B-A-R-B-A, at CapitalOne.com.
Yep.
Okay. That has been sent. I sent it from my personal email account. You should have that any moment. Everybody, all the other members have a chance to look at the plans? Everybody's got them?
Yep.
Okay, great.
Yeah, I'm looking at
I
it.
can share my screen with you all tonight if you want to. If you didn't get them here tonight, just now, I can share my screen with you know, and show them to you now. So let's give Peter a minute to get those plans.
Yeah, go ahead.
You got them?
Yep.
Wonderful. Okay. And so where we were in the hearing on that when we left off last time is that Mr. Kennedy had presented his case, and we reviewed the plans. We asked a few questions. We also asked if there was anyone there to speak in favor or against the petition. And then we made a recommendation that Mr. Kennedy revise his plans. So let's talk about the revised plans, go back our deliberation. I'm sorry, before we do that, let's see if anyone new here who would like to speak in favor or in opposition of the 156 Bass Point application. If there is anyone here who would like to speak in favor of 156 Bass Point application, speak now. Okay. No one in opposition? Speak against the application? Okay. All right, so let's do this. Let's get going with our review of the amended plans. Did anybody have any questions for Mr. Kennedy?
I'm good with it. I previously read the whole thing, so I'm fine.
Okay.
So essentially, I guess just a question, because I just read through the parking thing. So essentially, there was no need for any kind of change on the parking because the use didn't change?
That's what he's saying in his
Okay.
application.
That was specifically from Wayne.
Yep.
Anyone else have any questions on this matter?
No, I don't.
Okay. So
No,
we're still looking for the three areas of relief. Is that fair to say? Mr. Kennedy, are you still looking for 3 areas of relief?
Correct.
Okay. And those would be regarding lot coverage, regarding the right side setback, and regarding the open space.
Correct.
Okay.
And if I can comment on those, it's in there, but the right side setback, we kept it as is, the 5 feet plus. We reduced the overall coverage of the deck by about 40 square feet. And it's not really a deck anymore, it's a landing and the staircase.
Okay.
So what concerns me is the dimensional sheet and the letter are still the same that show a side setback of 1 foot or less. Obviously, the rendition that's being shown in the later photos,
Which
Yeah.
which one are you looking at? Which page are you looking at?
So
In the
page,
attachment.
page, hold on. After your initial letter, the Office of the Building Inspector, the letter dated April 16th, is the same as, I think, the last package. And the dimensional requirements are the same. And I'm just concerned. I don't want to, I want to make sure that when you move forward with your project, that the correct information is on the correct paperwork.
Correct. He didn't. It was not when I submitted the plan. I did not get a denial back again from Wayne. He did not deny. It wasn't a refile. He didn't have me refile the plan and then deny it with the new dimensions on it. I just submitted the new plan.
Okay.
So
So
Peter,
that
you need to look
setback-
at pages 8 and 9, I think. That's what
Yeah.
we need to look at.
Yes.
Yeah.
Yeah.
Jocelyn, I'm sorry. I just went through because I received a bunch of emails from you over the last several weeks, and I thought I saw these plans, but could you resend them to me as well, please?
Yes, I can.
Okay, thank you. I thought I looked at something, but I'm not finding it, so.
Okay, so what I'm gonna do is do the same thing I did for Peter, Donna, because I'm at my home computer. So what is your email address?
It's my name, Donna Lee Leonardo, at AOL. I just went through even old emails. I didn't find it. Sorry.
Okay. What I'm also gonna do right now, in order to speed things up, is I'm gonna share my screen with you so you can all see what we're talking about. Okay. So this is page 8, I believe, of the package. Page here. This seems to show us this particular these plans, they're not stamped, unfortunately. We would prefer that they be stamped. But this plan here shows the 156 Bass Point Road, 6.83, I believe, is the distance there. And it's a 5-foot from the lot line. Can you see that, Donna? And Peter? Everybody else?
I see it, yeah.
Okay. So that's what he's proposing now versus the deck that was there, but we recommended he take off.
Okay, so basically we went from 1 foot that we originally wanted to now back to the 6 point.
It's 5 feet.
5 feet.
5 feet, 5 plus, it's about 5.4 inches.
Oh. Justin, I'm trying to scroll up on your screen.
Yeah.
Okay,
It's the same width as the house, the same spacing as the house. We won't project past it, and that's to allow us to get to a 3/6 landing, the 42 inch in width by 3 feet.
5'3", yep.
Essentially have the same size deck though.
The deck is actually almost cut in half. Now it's the landing. The deck. So by taking the staircase and pulling the whole staircase around, we've cut what's not really a deck. It's a landing that's there. And you step out of the door to the right. You step down one, and then you go down the stairs.
Okay, because your only concern previously was the egress, and so with
Yeah,
that
that's the only
being
concern.
addressed, we were looking at a special permit for all 3 areas. And those are, and you're right, that Peter, that the sheet did not change, and that is the dimensional sheet did not change. But it's the right side setback, the lot coverage, and the open space.
So we've decreased the lot coverage and increased the open space.
You have the new figures on the lot coverage?
That's the problem.
Say that again?
Do you have the new figures for the lot coverage?
I don't have the percentage. It was reduced by 40 square feet. I could do them.
We just want to make sure that we need to still provide you with relief for that particular
38.
issue.
I can provide the exact number. I'm not exactly sure how Wayne did the calculation on it.
Okay.
Um,
All right. So the biggest issue that we had though was really this right side setback, and that's been taken care of with these revised plans. Does anyone else have any questions for the applicant?
Nope.
Nope.
Okay.
So we don't have a switchback set of stairs. We just have a landing and a set of stairs. Is that correct?
Mr. Kennedy?
It's effectively the landing and the stairs. What the initial? Could you scroll up to page 4? I believe it is.
Well, here's what you had before right here on page 7.
Yeah.
But you had
So there was
before.
a porch. There was a porch here. What I was going to describe was if you go up to the rendering of the new porch, I can show you. So here, yeah. So there's a landing that comes across, and there's a step down. We need 9 risers, and there's a step down. There's a full landing across the top. There's a step down to a smaller landing, and then the 7 risers going down to the ground level. there could be, the other way we looked at it was to have the landing off of the door, step down and have a smaller landing, narrower, but the full length, and then come down. That would effectively make it more of a switchback, but it's one step. And what we thought was that it's the same, effectively the same thing. And rather than doing it that way, you've only got about a foot from the door. Rather than stepping out to that 1 foot, give it a little bit more space, then step down to the smaller landing, and then come down the stairs.
So there's a
So
turn,
it's
it's a
six.
turn, but it's not a switchback stair, but there is a bend.
There's a bend, yeah, absolutely, absolutely. You're coming down one riser from that upper landing to the second landing.
Okay. All right, any more questions for the applicant?
Nope.
No,
Okay. Do we have any motions?
So, just one question, parking. What I don't understand is if the parking in the back didn't change because there was no C of O change or anything use change, then why is the front one, why do we need to give a variance or a special permit for the front one? You know what I'm saying? I don't understand the logic or the.
Well, we're required to have 2 spaces per dwelling.
Right, and they're only gonna have 3. And again, wouldn't this have come to us when the site was condoized?
You would think so. And I don't know why it didn't, it's not really, he says it's not changing use, so I'm not trying to agree with that.
Per Wayne's response, it was, there's no change of use or of occupancy to either unit. And therefore, there's no requirement for parking variance.
There is. It's right
But
on his dimensional requirement sheet.
I know.
You went
I
from
know,
a
and
single family to a condominium.
Right. You went from a single family to a condominium, and now you have 2 units instead of 1. Even though there were 2 houses on that space, you now have 2 separate owners. Therefore, you now need a requirement for 4 parking spaces, and you only have 3. So that's one special permit or variance that we have to allow for. And I don't understand when the division or the condoization of the house, it should have been automatically been referred to the zoning board because of the parking situation.
And I would have done that if that was the recommendation from the inspectional services. I would have been here last year.
No, it's not.
Yeah.
It's not your fault. I mean,
Yeah.
it should have been referred to us, but.
Yeah.
Okay,
going back to the last discussion, wasn't there actually another parking spot, but nobody wants to put a car in it?
right,
Up there
because
at the top?
it's next to a neighbor, right here.
Yeah. That's actually a parking spot.
We decided
So-
it was big enough for a parking spot.
It wasn't large enough?
Oh, we don't know. We don't have the
It's
like
the
how you
proper
put it.
dimension.
It's under the 8 foot from left to right. And in order to make it a parking space, we would have to narrow the staircase by almost a foot, which we had the space to do. But I was told by Wayne last year not to do that, and not to narrow that staircase, to leave it as is, to keep the work under the 50% rule. I was willing to change the staircase, and I was advised that I couldn't.
All right, let's stick with what we have in front of us right now, okay? All right, let's stay focused. All right, so we're looking at the 3 areas of relief. Is this something that we think that we can provide? Does anyone have any commentary on it? Here's the last plan with the, we need to stay on schedule as well, it's almost 7:30. Is this something that we think we can do?
I think so.
Yeah, I believe so.
All right, does anyone want to make a motion?
We have to do each one separate, is that correct?
Yes.
Okay. All right, so the first thing is the lot coverage, which is really less than 43% now.
Yes.
But we don't know the exact percentage.
It's about 39,
Around 39%?
about 39 to 40%. Yeah.
Okay,
It's only 40, it's 40 square feet, but it's only 40 square feet.
okay. All right, so I guess we can use that number for purposes of the motion.
Well, yeah, but the existing is 42.
What exists?
According to the dimensional sheet,
Mm-hmm.
the existing is 42%. That's without a landing or the stairway. So how do we get below that when you add a deck and a set of stairs?
Because you remember, David, Peter, before that, there was another structure out there that was.
Correct.
Yeah,
Correct.
there's a picture, he submitted a picture of it in the package.
Yes.
Right.
Yeah.
And it was much bigger. It looked much bigger, that's for sure.
It was 12 by 7.
It's much bigger than what's proposed now.
Okay, all right,
Yeah.
I see it. I think,
Yeah.
I think I
Yeah.
see it. Okay.
Yeah.
All right. All right, so I'll move that we allow for a proposed lot coverage of 39% for this project.
Oh, he said it might be up to 40%. Maybe we see 40 or not above.
All right,
40.
40%, yeah,
Yeah, 40.
David, why don't we do all three at once? Do all three
okay.
items at once. So
All right.
we're proposing that the lot coverage be 40%.
40%. And the right setback, right side setback is now 5 feet, correct?
That'll just
Yeah.
remain the same.
Huh?
That'll remain the same, is that correct?
Yes.
Well, it was gonna be one,
As a house.
Yeah, it's existing is 5 feet, so it's going to remain the same.
same as 5 feet.
So we
All right.
won't need any relief on the right side setback because that's not a new nonconformity. So we only need the relief on the lot coverage then and on the open space.
Okay,
Open space and parking.
in parking, right?
And sorry, parking as well.
Okay.
Yeah.
All
Because
right.
the lot coverage, because we're really not sure exactly how much it's going to be. We don't know the math of it. We don't have the math of it. So we'll include it to be on the safe side.
Is this an instance that we can put in that it wouldn't exceed?
That's a good point. Let's do that.
Won't exceed 40%.
Not to exceed 40%, okay. So David, do you want to start over?
All right,
We'll do the-
okay. I move that we accept the proposed lot coverage as not to exceed 40%. The proposed open space will be at 37%. And the proposed parking is for 3 spaces.
Okay, and are we going to make findings that those are, those 3 individually are not going to be more detrimental to the neighborhood than any current nonconformities?
Yes, I would say that's correct.
Okay. So that's your motion?
Yes.
Is anyone going to second it?
Yeah, I'll second it. David McCool, I'll second the motion.
All in favor? please state your name.
What was that again?
All in favor, please state your name.
In favor, David Walsh.
In favor, David McCool.
Peter and Donald?
Sorry, had to unmute. In favor, Donnelly Leonardo.
The same here. I was on mute. In favor, Peter Barber.
Okay, in favor, Justin Campbell. Okay, so we've made that finding, and so are we going to grant a special permit? Someone gonna bring a motion for that?
Okay, I'll move that we grant the special permit for the 156 Bass Point Road.
I'll second that. Peter Barber seconds it.
All in favor, please state your name.
In favor, David Walsh.
David McCool in favor.
Peter Barber in favor.
Donnelly Leonardo in favor.
And Justin Campbell in favor. Okay, so that, Mr. Kennedy, that special permit has been granted, and we will be filing that decision sometime the next week, along with the minutes from this meeting. And
Thank you.
did anyone have any questions on that? Did you have anything else? We all set? Okay. You all set?
Thank you. Thank you, Donnelly, for joining this meeting.
Sure.
Appreciate it. And thank you, the rest of you. Appreciate your time.
Thank you.
Thank you.
If all the members can stay on, we have 2 more matters to take care of. So at 7:30 p.m., we're going to talk about, the next matter is 2 Linda Lane. And with 2 Linda Lane, what we're going to do is we are going to have a couple of motions. As you all know, this is a matter that we decided some time ago. And this was in a hearing from the decision that we issued was in September, September
5th, 2018.
2018. And that matter was appealed and has gone to the land court, Department of the Trial Court. And on July 1st, 2020, the land court issued a judgment. And we're here to enter that. One of the things we're going to do tonight is enter that judgment right now. And so we're not going to be taking any testimony. We're just going to take care of the judgment and enter into it, our motions into the record and make sure we take care of that matter properly. So our decision regarding the retaining wall for that matter, for 2 Linda Lane, we are going to annul that decision. And then we're going to reverse the decision of the building inspector. And we're going to reverse and revoke that permit. So we need a motion initially. And who would like to bring that motion? Anyone?
I'll make that motion. I'd like to make a motion to accept the court's judgment and to annul our decision of September 5th, 2018.
And I will second that, David Walsh.
So Peter Barber brought the motion. David Walsh seconded it.
Yep.
And your decision to get could you read that again to me, your motion? To accept the court's judgment and to annul the
My
decision?
motion is to, of September 5th, 2018.
2018.
Regarding the retaining wall.
Retaining wall, okay. Okay, any discussion on the motion? All in favor?
Peter Barber, aye.
David Walsh, aye.
David McCool in favor.
Donnelly Leonardo, aye.
And Jocelyn Campbell in favor, aye. Okay, so then we'll need a motion for a finding in regard to the stone retaining wall. Would anyone like to bring that motion?
I'll make that motion. Peter Barber make a motion that the stone wall is in violation of the Nahant zoning bylaw 5.02J, and that we have to reverse the building inspector's denial of Mr. Gallagher's request for enforcement. We need to require the property owner to obtain a permit for the wall.
Okay,
I will second that, David Walsh.
any discussion on the motion?
None?
None.
Okay, all in favor?
Aye, David Walsh.
Aye, Donna Leonardo.
Aye, Peter Barber.
David McCool, aye, in favor.
And Jocelyn Campbell, I am also in favor. And so at this time, for 2 Linda Lane, we have at this point accepted the court's judgment. We've annulled our decision in regard to that matter. And we have reversed the building inspector's denial of Mr. Gallagher's request for enforcement, thereby requiring the property owner to obtain a permit for that retaining wall. Okay,
Is there any
I'm sorry,
opportunity for, is there opportunity for public comment?
certainly. Like, we normally, I don't, we normally would.
So I represent Mr. Gallagher. I'm sorry?
Mr. Sullivan, we know who you are. Yes, how are you, sir?
Well, I'm curious to know how the decision can be made without any deliberation. And the thing I'm particularly concerned about is the issue of the appropriate remedy at this juncture. There seems to be and I have had communications with Mr. Scripp, who represented you all, or some combination of past or present board members in the hearing. And it seems to me there seems to be this idea that there necessarily has to be a proceeding now where it goes back into the hands of Mr. Wilson, who originally decided the matter for a new building permit. And it seems to me that one of the outcomes in a situation where someone has built a structure without an appropriate permit is to have a hearing with evidence from both sides to determine what is the appropriate remedy in that situation. Anywhere from let them go ask for a new permit, or if it's an egregious violation and they really shouldn't have done this, to order them to take it down. And I guess I just don't understand why there isn't any consideration of indeed accepting evidence, accepting testimony, and considering, because when there is an enforcement situation, this board stands in the shoes of the building inspector effectively, and accordingly should decide what an appropriate remedy is in a given situation. There's a building permit that's already pending, and there are all the same violations that previously existed are still in place, are still impacted by the permit. Mr. Wilson, who's the person who heard it beforehand, is going to hear it again, and there just seems to be this, you know, we don't have a good feeling about this, given how this is unfolding and transpiring as we speak, notwithstanding the court's judgment. So
Okay,
I just
so
want to
what
voice
we-
my
just make
concerns about all of it.
Certainly. Let me just explain to you that what we are doing right now is just simply doing what the court told us to do. The court told us to make sure that by August 30th, that we enter this judgment into the record, which is what we've just done. So you're certainly welcome to have public comment. And if there's any problem with the new permit, which I can't imagine that there would be, under considering the fact that the board has decided in your client's favor, then you could certainly come back before us. Dan Scripp, counsel for the town, is here. Did you have anything you'd like to add to that?
Yeah, you're doing just what Judge Roberts asked you to do, and that's sending it back to Wayne to determine the appropriateness of a building permit regarding that retaining wall. And Mike Sullivan. I love Mike, but he's a bit overstating his case. Judge Roberts never found any other violation other than the retaining wall. She found 0 other violations. This is the only one she found, and she was very clear in sending it back to the building inspector for his review. And I've actually allotted Mike the space to provide stuff to Wayne that he thinks might be helpful in his argument regarding the denial, so to speak, of the building permit. And Wayne will have that should he need to make a decision within the next few days.
Okay. So there you have it, Mr. Sullivan. This is what we were asked to do by the court, and that's what we're doing. If there are any further problems, you can be assured that we'll fix it immediately and the best we can.
Well, thank you. I'll just, I'll respectfully disagree with the decision of Mr. Scripp, but thank you for hearing me. But if I just have, it's difficult to hear. one thing I just wanted to try to make clear for future reference, if there is an issue, if we continue to take issue with future action by the building inspector, is that is it possible that the board could make an additional finding, as the chair has indicated, that we may come back to this board with respect to the merits of any decision by Mr. Wilson on this new building permit application?
Of course we could, if you came back to us again with a further problem. But I don't expect that you will have any further problems. Yep. We will certainly do that. Okay.
I should point out that, Mike, there's a process, as you know. You have to file a request for enforcement and then come to the board from there. I don't think you have the ability to come right to the ZBA if you don't like Wayne's decision. I think you have to follow the process, and we can, of course, expedite that as quick as we can.
Yeah, I'm not sure I do either, and that's why I was hoping perhaps the board could condition its remand on a review of what's done. And I think it certainly would have the power to do that, to say, as the chair has indicated, that, you know, it should, you know, have some control over the matter, given everything that's transpired, and have it come back before this board, because you know, what would be unfortunate to happen is okay, the permit is acted upon, and notwithstanding the spirit of this discussion, that the board would be willing to you take a look at how that went and make sure everything was above board. You know, then you, Mr. Scripp, there's an objection interposed saying, well, no, you can't do that. You have to go to this other board or do an enforcement directive or the like.
Well, I haven't been instructed to put any further conditions on this matter right now. So I think let's just see how this happens, see how this works for you. I don't expect you to have any problems. If you do, you come back before us and we will address it. Mr. Scripp, Attorney Scripp, did you want to add anything to that?
I'm sorry, I missed that.
Did you want to add anything to that?
No, I think you said it right. The procedure is there, and Mike very well knows our procedures, and he certainly will take advantage of them. There's no doubt in my mind.
Thank you.
Thank you.
Did we vote? Did you guys vote on that? I may have missed it.
Not yet. I'm going to right now.
Okay.
Okay, so we have voted on both of the motion to accept the court's judgment and annul our decision. We also took a roll call vote on the motion for finding that the stone wall was in violation of the Nahant zoning bylaw 5.922J. And then we reversed the building inspector's decision and regarding Mr. Gallagher's request for enforcement, thereby requiring the property owner to obtain a permit for that stone retaining wall. And I'm sorry, I think we both vote. We don't need any further votes on that. Okay. And I think we can move on. Attorney Scripp, is that sufficient? Is there anything else you wanted from that?
One more time, Jason. Justin,
We've already
sorry.
taken the two votes on the two motions that we had.
Yep.
Was there anything else you wanted us to do for that?
No, not on two Linda Lane. I think we're good to
Okay.
go.
I think that's good.
And Mike
All
and I
right,
are in
thank you.
constant touch, so we have a good communication stream. So.
Okay, good. All right, let's move on. At 7:48 now, at 7:45, we had scheduled another citizen, another prior applicant had wanted to come in and speak to us. Mr. Paul Smith, are you on the line? Are you there?
I am, Jocelyn, I am.
Okay. Could you please tell us what it is we can do for you this evening?
So first of all, I'm having a real hard time hearing most of you folks, and I didn't hear your last comment. I heard you say please, so I don't know what you said there.
So please tell us how we can help you this evening.
Oh yes, okay. So number one, if you can't hear me, please tell me, and I'll rephrase it. I've got a couple of issues, concerns, and a couple of comments. Number one, I don't see it discussed in either the original decision or the amended decision. That has to do with the three-part hearing we had last fall that ended on December 5th, 2019. But it did happen. The board voted to issue a cease and desist order on the project at 96 Willow Road. And not having anything written in the decisions, I had to go back to my tape, and fortunately it was active and it recorded things. So on 10/30/19 at about 52 minutes on my tape, it's going to be different from someone else's. Dave Walsh made a motion, quote, that all work on the project be halted except for draining the heating system, unquote. It was seconded by Peter Barber, and then there was a unanimous vote in favor. It was not conditional on anything else, or it was just, that's my vote. That's the motion and the vote. So the first thing I'm talking about, obviously, is a cease and desist order. Then at the continued hearing on December 5th, at 2 hours and 13 minutes, again on my tape, after there was a discussion on of Max Casper's motion to rescind all permits, which I believe should have been done, of course, Donnelly Leonardo stated, quote unquote, I don't want to be a fly in the ointment, but we voted on a cease and desist in the last hearing, quote unquote. And Dave Walsh interjected, quote, we never revoked that, unquote. And Madam Chair, there was some discussion going back and forth, and you added, we can, quote, leave things as they are, and you didn't finish. And then the board talked back and forth and proceeded to do nothing further. So the cease and desist was voted upon and approved on 10/30. It was discussed again on 12/5, and it was not rescinded, revoked, or anything of the like. So it was in good order. So there is a cease and desist order. Mr. Rizzo apparently knew about it, and he abided by it. He didn't do any work on the house until the bill inspector recently concocted this scheme to amend the permit and bypass the ZBA and its orders. So I'm looking for the board here. You voted for a cease and desist because it was the right thing to do. And it seemed like you want to let things play out in court. And my request is that you confirm the cease and desist now. And we are coming close to a head in our court actions. So I think it's appropriate to continue that cease and desist. And I have further, but I'll go on. I'll do the rest now as well. The reason this is back in front of us is because I had sent a request for enforcement that Mr. Wilson first said I didn't receive it till such and such a date, and then he says I received it, and then he made a statement that was the opposite of that. He said I received it later, and he amended the permit, and he said everything you said in your request for enforcement is correct on the date that he received it, but after the fact, hey, let's move ahead, and we amended the permit so it no longer is valid, your request for enforcement. The amending the permit at this juncture is totally inappropriate. The board failed on several occasions to rescind the permit. I believe it should have been done by your operation of law as soon as you voted that the project was in excess of the 50% rule. That would have been avoided. But you guys voted that down for some reason. And Max had forecast that. He said, it would make things much more clear. There'd be clarity to rescind it. Interestingly enough, at the December 5th hearing, several members of the board made opinion that was on the record during discussion that we, quote unquote, we wouldn't amend the permit at this point. That was Max Casper. And Madam Chair, you added, absolutely, and you agreed. So, and I have that at 1 hour and 56 minutes of the meeting. Also, I just found this the other day, happenstance, but you folks the board has rules and regulations. It's on the website. It's paragraph 2217, modifications, and I'll read it to you. Requests for modifications or changes to the language, terms, or conditions of previously granted permits shall be heard at a public hearing unless the chair, with the approval of a majority of the board, determines that such changes are de minimis and that a formal public hearing is not required. Such modifications or changes shall constitute an amendment to the original permit. I read that on its face as saying, when you're in a situation like this, if you're looking to amend a permit, this board, your board, has to hold a public hearing and discuss it. So clearly no hearing has taken place. So the building inspector stated that everything, I'm sorry, the building inspector's modification or amendment doesn't stand. And if that doesn't stand, then what does stand is his initial comment that everything you said in the request for enforcement is correct. And if that's the case, then this permit has to be rescinded. So I respectfully request that we stop this skullduggery that's going on up at the building inspector's office, that you rescind the permit. And if you're not willing to do that, at the very least, confirm the cease and desist order and let this play out in court. It's the only fair thing to do.
Okay. Mr. Smith, you have ongoing litigation against the town.
I'm sorry, Madam Chair, I can't hear you.
Okay.
Yeah.
There's a lot of background noise because someone is doing something, somebody on this list here is not on you. And I think it's pretty that you may want to respond to Smith because we have ongoing litigation, and I'm not sure it's appropriate for us to respond to you tonight.
So I'm sorry, Madam Chair. Again, I hate to say this, but I haven't heard a word you said here.
Okay.
Does everyone else hear the chair?
No, Jocelyn, I'm having problems hearing you as well.
Okay.
Dave McHugh. Dave McHugh.
Yeah.
Mute your phone or computer, please. Mute. Yeah. Thank you. That should be better.
Donnelly, that was perfect. Thank you.
Donnelly, you're a technician.
That's because I spend a lot of my time on this thing.
I hear you.
Okay. So, Attorney Scripp,
Yes.
do you feel as though you want to respond to Mr. Smith, where we are in the middle of litigation? The town is, Mr. Smith. I can tell you that it was never my understanding that we had an open cease and desist order. I can tell everybody that. Because my understanding is that we had one at one time, and that was simply until the next hearing, and we came to a resolution, and we did that. And we now have a situation where my understanding is that Mr. Rizzo has come into compliance with the floodplain regulations, and it's not before us tonight. None of that is before us. Is that correct, Mr. Smith?
That's my understanding, and I've been clear with Paul that there was a cease and desist in October. My understanding has always been that was just a bridge between hearing number one and hearing number two, so to speak, or A and B, wherever you put it. What didn't make it to the final decision? It's what you call an interlocutory order in the legal terminology. It didn't make it to the end, so I didn't see it as anything that was standing to bring to a court. And in terms of the amended or modified permit, that's not before you tonight. If Paul wants to challenge that, he's certainly able to through the avenues of which he's very, very much aware. But none of that's before you guys tonight.
We wouldn't be able to act on it anyway, Mr. Smith. But we do hear you. We do hear you, and we've tried all along, as you know, to listen to both sides of that story. We've had at least 3 full hearings. I think there was another one as well. And we spent hours the last night going over every possible finding, debating every single piece of it. We did our best, and here we are today. And I'm sorry that it wasn't, didn't satisfy what your concerns were. We certainly tried very hard. So that's what we are. Thank you for your
Well, so first of all, thank you, Jocelyn, for putting me on and hearing me tonight. So I appreciate that. But I take exception with what Mr. Scripp said. I just read to you after listening to the tape ad nauseum. And by the way, I did get a greater respect for the issues that you folks, you were troubled and you went back and forth and were discussing. So it gave me some greater appreciation. So that's something anyway. But you guys did vote for a cease and desist originally. It was not coupled with, it was a bridge between something or an interlocutory order. That's BS. The very fact that it was discussed at the next meeting by members of the board brought it up, hey, by the way, there's a cease and desist order out there. And then it was confirmed. We did not revoke it. And then there was a discussion about it. That means that was standing. It didn't make this up. This wasn't, Mr. Scripp says it wasn't in the decision. Of course it wasn't. But it did happen. We all heard it. Attorney Murphy said, well, it happened. Yeah, and, I played in the tape because, well, there it is. So it did happen. It was there. The only fair thing to do is to continue that cease and desist and let this thing play out. And by the way, we're missing entirely your rules and regulations. It says modifications have to be at a public hearing. Now, people could read that differently, but the plain letter is as I read it to you, and you guys can look at it, on your, on the computer, 2217.
We're pretty aware of those because we wrote them and we put them in there.
I got you. Okay, so modifications of previously granted permits shall be heard at a public hearing. So
we're going to have to just cut you off right there because that matter is not before us tonight, Mr. Smith, and I'm very sorry to have to do that. We did.
Your rules, though, ma'am. I mean,
we did hear you. We did hear you, and we are planning. We are looking at everything all the time, but right now we can't even respond any further. We have open litigation with the town. I want to leave that to Attorney Script to respond to any further.
Yeah, I hear you, Madam Chair. But same thing with Mr. Script. Oh, open litigation is the excuse not to actually discuss it. The board members who were sitting there hearing this know that they voted on a cease and desist. They also know that they didn't rescind it. So if they voted for it and they didn't rescind it, it stands. It cannot be rescinded by somebody else. You're the boss of Mr. Wilson, not vice versa. And if you choose to vote, hey, we're gonna remove the cease and desist, I guess you can, but I don't think you should. But you board members who are sitting there who aren't saying anything, you voted for that. And you know also that you didn't rescind it. I'd like to have you folks speak up on this.
All right, I'm going to speak. Mr.
That
Smith,
was a
I'll speak up on it.
order.
Mr. Smith, I'll speak up on it. It's exactly as Mr. Script and Ms. Campbell said. We put a stop order on the project until the next hearing. It wasn't a cease and desist on the entire project. It was just a kind of a pause so that we could get more information and allow Mr. Rizzo to either decide whether he was going to bring his house to FEMA compliance or not bring it to FEMA compliance. It wasn't a cease and desist order to stop all work forever and a day.
Thank you for answering, Peter. I read you the transcript of the tape. It wasn't conditional on anything else. It wasn't limited in time, and it was confirmed at the next meeting. Donna Lee and Dave Walsh both said, "Hey, it's out there," and he says, "Yeah, we haven't revoked that." And then there was a question, "Should we or not?" And it was not done. You can characterize it any way you want. You choose in the chair care to characterize it of exactly what Mr. Script says it is. But that's not what happened, and that's not what the tape says.
Okay. So I think we're kind of going around in circles here. So I think that's enough.
Well, we have.
There's nothing more we can do for you right now, Mr. Smith. I'm very sorry.
Well, so you have a cease and desist order that's outstanding. You can choose to rescind it. If you don't choose to rescind it, same thing with the permits, then it still stands. So if you don't rescind it, that cease and desist order still stands.
I would disagree with you. I don't believe there's a cease and desist order out there, and there's nothing to rescind.
So if I put these download these tapes, the segments that talk about this, put it in do some work here to put it on the internet in a file, send it to you folks for your review, and it talks about that there is a permit and it's not conditional on anything else, and that it has not been revoked. Would you say it still stands?
Attorney Script, do you want to answer that?
I wouldn't comment on anything until Paul produced something. And I'll point out, I've asked Paul for this evidence probably for over a month now, and he's not produced any of this stuff that he is claiming that is on the tapes now. So I would advise not to make any sort of finding until Paul does actually produce.
So Dan, what you said to me is, I'm not aware of any such order. And my response to that would be, go find and look for it.
No,
as opposed to put it on me. Well, no, or ask the chair, hey, was there an order type of thing? So, Mr. Script, when I produce the discussion on this, Is that going to be the aha moment? Yes. There is an open cease and desist order. It still stands, and
Mr. Smith,
therefore
our
it's still in
intention on
effect.
that matter was never to do that. Our intention was whatever you think you may have found, whatever discussion we had during deliberation, by the way, is not part of any decision. We discussed a lot of things during our deliberations, but our intention at that time, and I think we're all in agreement, that it was a temporary stop, pause, as Peter said earlier, and the purpose for that was to allow Mr. Rizzo an opportunity to make that decision, either provide the information he requested or bring his house up into the FEMA regulations, to meet those regulations. Because we had ordered that he was beyond that rule. We never had a permanent cease and desist order in place against that property. So that's our intention. That's exactly what we all seem to agree upon, and that's whatever you may think is different. Again,
Well, I thank you for allowing me to speak. Your decision or your feelings on it are as I expected. You know, Mr. Scribb counsels you to say certain things in other folks. I didn't hear from Donna Lee or Dave Walsh on this, or Max Casper, I guess, is not there. But the tape doesn't lie. And it says there is a cease and desist. They talk about it at the next meeting. They state it wasn't revoked. Then discussion ensues whether it should be done or not. And it was not done. I didn't make it up. The fact it didn't make it into the decisions is telling on the board, not on me.
Well, thank you for your comment tonight.
It happened.
Thank you. I'm sorry, Bob, there's nothing we can say about this right now.
I'd like to make a motion that we adjourn.
And who seconded that motion? Dave Walsh? Any discussion on the motion? All in favor, please state your name.
Peter Barber, aye.
David Walsh, aye.
Donna Lee Leonardo, aye.
David McCool, aye.
Jocelyn Campbell, aye. Thank you, Donna, for coming. Thank you, Donna Lee.
Thank you.
Guys, bye.
Take care.
Good
Thanks.
night.
Bye.
Bye-bye.
Good night, Dave McCool.
All right. See ya.